Hey everyone, Harry here to talk about Trump's appeal of the Secretary of State of Maine's decision to disqualify him from being listed on the ballot. By now, you've seen probably the Maine Secretary of State kind of making the rounds and pushing back against what does strike me as pretty spurious criticisms that how could she even decide this matter? And, other states like California have said, yes, it's a qualification, not being an insurrectionist, but it's harder than, say, is somebody 35 or not. And to be sure, it is. But I think the Secretary of State pretty persuasively says, I still have to do the best I can. And that was the 34-page opinion that I think was pretty methodical and thorough. All right, but Trump now challenges it, and it's important that under Maine law, technically what has happened is this has been an administrative ruling. It does now go to the courts, first the Maine Superior Court, where it now is, or where his challenge has been filed. After that, the Maine Supreme Court, and only after that, the U.S. Supreme Court, but it does on the narrow deferential basis of review that is generally the case for agency action. This is true in the federal system, the state system. By and large, if you're challenging an agency decision, you need to show that it was, quote unquote, arbitrary and capricious. It's not enough that it was wrong. Basically, it's got to be off the reservation, not applying the right law, etc. And, that's makes it a lot harder for Trump to prevail. But B, I think if and when it gets to the Supreme Court, it complicates the question. We already know 14th Amendment Section 3 is all kinds of headaches trying to figure out how it works. But in a state like Maine, a single elected official, and Trump's main claim is basically this is a biased official who's already expressed her conclusion that he was an insurrectionist before this, but a single official can make the determination, and now it's subject to arbitrary and capricious review. So not even the full review of the courts. And is that enough to kick a president off the ballot? It's going to be part of the general problem for the Supreme Court, sort of the main one, that they are looking at different regimes in different states and how are they going to make a consistent federal response. There'll be much, much more about that later. All right, but back to Trump. So it's a kitchen sink kind of petition to the court saying it was arbitrary and capricious. So we do have a preview, basically, of every argument we are going to be seeing from him as this whole, not just here, but in other states as it proceeds upwards toward Supreme Court review. First, there's a special one for this Secretary of State. Hey, she's biased. It was an infected process. And, she's a Democratic office holder. She has criticized him. I think she even called him an insurrectionist in the past. It was a very, as I say, methodical, analytical, professional opinion. On the other hand, if she were a judge and had said the things she had said, she would have needed to be recused. So what's the motion for, secretaries of state are political officials, and it's really not surprising, but that would be one claim that maybe the Maine Superior Court would embrace. Okay, next we come to the claims he's going to make under 14th Amendment Section 3. First, he wants to say that it is, quote unquote, not self-executing, a term that's a little arcane, but we should know by now. What that means is you can't just apply it. You need something else. For example, a vote or resolution by Congress saying that Trump is an insurrectionist, possibly a conviction for insurrection in a federal court, but something of that nature. It's not enough simply for a court to look at the facts and say, it looks like he engaged in insurrection, and on that basis. Then there's a whole welter of very technical Maine specific claims, like the declaration that he made didn't state the qualifications, just the statement did, and we're challenging, in theory, the declaration, and nothing's wrong with that. Oddly, when it states the qualifications for office that he said, I meet them, it doesn't seem to include 14th Amendment Section 3. It includes being over 35, born in the States, etc. So Maine specific stuff that I'm not sure how it gets resolved. And if it does, it would probably be the end of the road for this particular challenge. But it seems likely to me, based on Trump's track record, that it's sort of throw it against the wall and see what sticks kinds of arguments. And then remember, it's all under, she also says there's not enough facts. He didn't get enough due process, et cetera, et cetera, et cetera. So it's all, recall, under arbitrary and capricious review. So it shouldn't take that much as it would for, say, the Colorado Supreme Court to just uphold it, pass it up to the Maine Supreme Court, and then the U.S. Supreme Court, on the one hand. On the other, the very fact that it is that way might give some heartburn to the Supreme Court. But you definitely have in his petition a preview of everything that's going to be playing out, hopefully soon, in the U.S. Supreme Court. And now there's a challenge here by a person, so that person may well respond in the Maine Superior Court. And then that court will rule, and then the Supreme Court, et cetera. We don't know that it'll be expedited as others have been. It needn't go all the way up to the Supreme Court nor for the court to take the issue, because they have Colorado, and there'll be awareness of what's going on in Maine, whether or not that case ripens and reaches them. So the big thing, as I've said before, just that it's different. We have two really disparate procedures for knocking him from the ballot, and to the U.S. Supreme Court, that's going to be an occasion for heartburn to try to figure out what can we do to avoid the situation where he's on in some and not on in others. That will sort of cast a shadow on the Colorado petition. And just a final word on the Colorado petition. Trump is supposed to file, in theory, by tomorrow, but his co-party, the Republican committee, did it already. And by the terms of the order, the mandate of the Colorado Supreme Court is stayed. So for now, the U.S. Supreme Court has the Colorado Republican Party in front of them. It also has the winning party, the challengers in Colorado. They've both said, take this and expedite it, U.S. Supreme Court. U.S. Supreme Court has its next conference on Friday, January 5th. But it's a little bit of a funny situation because they don't have a request from Donald Trump, which is, what everyone is sort of waiting for. They can still take the case, and that would force him for sure to jump right in. But as of now, is he trying to play a waiting game, knowing that the stay remains in effect because the Republican Party has filed a petition, and that triggers the continuation of the stay under Colorado Supreme Court. Okay, so that's where we stand as of this morning. Very quickly moving target on the 14th Amendment, Section 3, throws the sort of a kitchen sink brief from Trump previewing things he'll say in the Supreme Court as well. And arbitrary and capricious review, and a fair way to go. 2 more court decisions before it would even be ready for the U.S. Supreme Court. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.